Sir Julian Hunt. I'm absolutely delighted to see so many of you here. This talk is very much the brainchild of Michael Kellyan. It's entitled Jerusalem and Misconceptions. And I'm really, really excited to have talking to us Natasha Hausdorff. Natasha Hausdorff is a barrister at Six Pump Court Chambers. She serves as the legal director for Israel, for UK Lawyers for Israel Charitable Trust, and she sits on the committee of the UK Association of Jewish Lawyers and Jurists. She was a fellow in the National Security Law Program at Columbia Law School in New York and clerked for the president of the Israeli Supreme Court in Jerusalem, Chief Justice Miriam Naor. Natasha has a law degree from Oxford University and an LLM in international law from Tel Aviv University, where she focused on public international law and the law of armed conflict. She originally qualified as a solicitor at the commercial law firm, the American white shoe firm, Skadden Arps. She then worked for them in London and Brussels, and she speaks frequently on international affairs, foreign affairs, and national security policy. It's quite an incredible CV for someone as young as her, compared to a South London hack like myself in particular. We're going to talk for about 15 and 20 minutes, Natasha and myself, and then we will open it up to questions from you all, because I know you're all going to be absolutely eager, keen to ask questions. If during the talk between Natasha and I on Jerusalem misconceptions, you want to butt in or join in, then feel free to use the chat function at the bottom of the screen. Luckily, it won't be used for updating us on penalty scores in the England match. It would have been my nightmare. So, Natasha, Jerusalem and misconceptions. The first thing, please, I would like to ask you is about Sheikh Jarrah. I'm presuming I'm pronouncing incorrectly, but if you could please explain to me the significance of that particular dispute over what appears to me to be a number of properties. There are evictions going through, and what are the misconceptions over that, and how that became such a huge issue, please, and especially in May of this year, please.
Julian, I'd be absolutely delighted. I wonder if I may cheekily take a small prerogative and perhaps do what may be quite a substantial introduction before we get into the specific instance of Sheikh Jarrah, which of course has been through the headlines all of, well, 2 months ago now, more or less, and has remained in the headlines. I think there were just articles earlier this week and indeed earlier today on the situation there. But first of all, thank you so much for the introduction. And I have been honoured to be involved with UK Lawyers for Israel for quite a substantial amount of time. And that is, of course, how I got to know you, Julian. One of the many areas that UKLFI contends with is the misrepresentation of international law vis-a-vis Israel. And we see that accusations that Israel violates international law are thrown around really without basis or justification. But the difficulty is that, of course, international law can be quite complex and it can be very easily misrepresented, and it is misrepresented in relation to Israel. It is an area in which law and politics often overlap, but more than anything, I think we have seen a special language of condemnation which has developed in relation to illegal settlements, inextricably linked with illegal occupation, which are unique in terms of their use with respect to Israel, and contrary to the manner in which international law is applied elsewhere. So what I would propose to do, and I appreciate it might be a particularly long preamble, but I think it's crucial, is to talk about what international law can tell us about the legal status of the territory, and within that context, look at Jerusalem, and also I think importantly the settlements issue, because these are all intimately connected in the way that the international law is misapplied or even abused. So international law is very different to domestic law. It's a body of rules that are recognized by nations as binding them in their relations with one another. And there are two important sources to be mindful of in the context of our discussion. Treaty law, that can be written agreements between states bilaterally or multilaterally, and it's like a contract. A multilateral treaty is often referred to as a convention. And this is law that states have signed themselves up to and bound themselves by. The other key source to note for our purpose this evening is custom. Now, international customary law develops over time, and it is said to develop out of a general practice which is accepted by law, accepted as law, I should say. So what that means is that if a sufficient number of states behave in a certain way, believing themselves to be bound to behave in that way legally, at some point, that issue, that point crystallizes into customary international law. The behavior generates the customary rule of international law, which then binds all states. Now, there's a big misconception, which I think needs to be addressed briefly, and that is in relation to UN resolutions. UN resolutions very rarely have legal effect. They're generally not a source of law. These are political as opposed to legal instruments. Generally speaking, only Security Council resolutions that have been made explicitly under Chapter 7 of the UN Charter, and this is very few resolutions indeed, only those are legally binding. And the reason they're rare is because I think it makes sense. It's a lot easier to pass a political resolution, a resolution without legal teeth. Examples of that include Resolution 678 in 1990 with respect to Iraq. That's where the Security Council gave Iraq a set period to withdraw from Kuwait, and it empowered states to use all necessary means to force Iraq out of Kuwait after the deadline. And another famous example is Security Council Resolution 1373, which was in response to the 9/11 attacks. It was also famously made under that Chapter 7 rubric, but they are very rare. With that, let's come to the status of the territory. And this fundamental rule of customary international law that establishes the borders of newly emerging states at independence, as in Israel's case in 1948. This is a rule of custom that is universally applied. It developed in the 19th century. It was applied in South America. It was later applied in Africa and Asia, and still later at the disintegration of the former communist federations. And it's been applied to all the states that emerged in these cases. It's also been applied to states emerging from former mandates. The universal rule for determining the borders of newly emerging states at the moment of independence dictates that the new state takes on the boundaries of the pre-existing administrative unit as its international borders. Now we'll look at what that means, but the rule is called uti possidetis juris. I promise it's the only bit of Latin that I'll be using. It's the default rule. So anywhere there is no agreement to the contrary, this rule is universally applied as a matter of customary international law to provide certainty, to avoid frontiers being challenged, and to avoid wars breaking out, to promote peace and stability. Those were the reasons the International Court of Justice recognized as being behind the development of this fundamental rule. Now, another fundamental rule of international law is its equal application. You cannot have a general rule and an exception for a country you just don't like very much, or you have some political or ideological opposition to. That is not how any respectable legal system can operate. So the question is, what does this rule universally apply tell us about the legal status of the territory in Israel's case? Well, in 1948, the administrative lines of the eastern side of the British Mandate ran along the Jordan River all the way to the south, originally dividing it from the separate administrative unit of Transjordan, which became the Hashemite Kingdom of Jordan. And by the way, Jordan's borders also followed the rule of uti possidetis juris. And if it's helpful, maybe in terms of the questions, we can share some maps to illustrate this. But the key issue is that Israel as the only state to emerge from that mandate territory in 1948, automatically assumes as its international borders the administrative lines of the mandate, and that includes East Jerusalem and the West Bank, which was occupied by Jordan in the 1948-1949 independence war, that Israel's independence war. Those same areas were recovered by Israel in 1967. And this is crucial, as we'll come to see, to the issue of Jerusalem. Because the legal status of the whole of that territory applying this rule, which is universally applied, and there is no convincing reason here not to apply it. The effect of that rule is that it dictates that Israel was the sovereign there in 1948. Now, there's been no agreement of any kind on the transfer of sovereignty since 1948, but there can be unilateral actions taken by Israel in relation to relinquishing sovereignty over parts of the territory. And there is an argument to say that Israel's done just that with the unilateral withdrawal from Gaza. And we'll come on to what Israel did in relation to the West Bank and Eastern Jerusalem. But the starting point is crucial because it tells us that Israel's presence in the territory is entirely lawful. And crucially, it is not a situation of occupation, which I suggest is another misrepresentation. This is, I think, a brief but important aside. The framework of the law of occupation developed in public international law, not to protect the rights of ordinary people, but to protect the rights of a former sovereign during a period in which they were ousted from their territory. So even if one were to quibble with customary international law and reject the application of uti possidetis juris, to say that the universal rules under international law for some reason do not apply to Israel, there is no other sovereign that has been ousted from their territory which would trigger the proper application of a situation of occupation. The occupation framework in which, crucially, the Geneva Conventions are applied does not work where there is no sovereign from which Israel acquired the land. I've explained Jordan, which controlled the territory before 67, was not a legitimate sovereign. If anything, it was occupying that land between 1948 and 1967 from Israel. And of course, it did not comply with international law in that it ethnically cleansed Eastern Jerusalem and the West Bank of all of its Jews. And the occupation framework also does not apply after a peace agreement, such as the peace agreement between Israel and Jordan. It's again another crucial aspect that is universal, but for some reason overlooked when it comes to Israel. So that's the general picture on territory. And now to pick up on the issue of Jerusalem and to answer the question, really, what did Israel do with its rights, legal rights, with respect to Jerusalem? And here it's important to realize Israel's declaration of independence does not contain any reference to Jerusalem. It does not specifically mention borders at all. In 1949, the Knesset decided that Jerusalem would be the capital of Israel. And on the 26th of December, 1949, the Knesset held its first session in West Jerusalem. In 1950, the Israeli parliament again declared Jerusalem to be the capital of the state of Israel. And when Israeli forces ousted Jordanian forces from East Jerusalem and the West Bank in the Six-Day War, ending on the 10th of June, 1967, Israel immediately took steps to extend its law, administration, and jurisdiction over the whole of Jerusalem, using the terminology areas formerly part of mandatory Palestine. And that's key. It's also wording that is mirrored in the ceasefire agreements and indeed peace agreements that later came to be between Israel and Egypt and Israel and Jordan. All of that is taking us back to the crucial importance of uti possidetis juris, because it's the mandatory boundaries, the administrative lines that are always being referred back to. And so Israel, the Israeli Knesset, passed the Law and Administration Ordinance in 1967 in order to effect this. And also, crucially worth noting is that in 1967, in July, then Minister of Foreign Affairs Abba Eban informed the UN Secretary General in writing that its acts did not constitute annexation. And that, I think, is particularly pertinent in the context of the debate that was occurring last year with, I would suggest that the wrong use of that term, but we can certainly come on to that if we've got time. The Israeli Supreme Court has considered the legal status of Jerusalem in pretty crucially in a 1993 case called the Temple Mount Faithful Association and the Attorney General. And this related in particular to the Temple Mount. And the court confirmed that the Temple Mount is part of the territory of the State of Israel, even though, of course, Israel has given the Jordanian Waqf authority over that site. It held that the laws of Israel apply to the Temple Mount and Jerusalem in full, and those are laws that it referenced guaranteeing freedom of worship, right of access and protection against desecration with respect to the holy places. Now, in relation to the West Bank, we have a different story. Israel did not apply its law administration and jurisdiction in the same way that it did in Jerusalem. Instead, it established a temporary administration, anticipating, I think, that as part of a peace negotiation with Jordan, territory may well change hands. But of course, that temporary administration has lasted over half a century. Julian, you didn't ask specifically about settlements, but I think we've come so far. I might just say a few words on them.
Before you do, I want to ask about the term settlements. Is the word settlements, the term settlers, is that recognised as a phrase or a term in international law?
No, and it's not used elsewhere, really. Certainly not with it has no legal meaning, and certainly the notion of an illegal settler is also devoid of legal meaning. And I think if we come on to look at a couple of examples of how, I don't want to say similar situations, but I'd say situations of real occupation, real transfer situations are viewed around the world, that contrast will come into really stark light. Mm-hmm. It is a political term, not a legal one. I think that's probably the best way of explaining it. But I think the first thing we have to acknowledge when we're looking at the question of settlements is the absence of an international consensus on a legal framework which properly addresses the territory. And that feeds in, of course, to the terminology that is used. So what I think is best to do is look at the legal mechanism which forms the basis of criticism of Israeli settlements, and that has been on the basis of the Geneva Convention, specifically Article 49 of the Fourth Geneva Convention. Now bear with me here. It is actually, I think, quite straightforward if we break down that article.
Before you go, I just want to, there's something from the chat. This is from Morris Solovitz. It says this, the issue is that the Hebrew is translated by Israel as settlements, and Israel has never come to terms with the negative propaganda value of the term. Is there something you would like to say about that particular comment at all?
Well, the way that the Hebrew term is translated into English, I agree with the questioner, is probably the key of the problem here. In Israel, that you don't have a notion of a settler. These are simply villages. And you can have villages of this type all throughout Israel. There is no specific word which has been developed to differentiate those that happen to be positioned in the West Bank as opposed to anywhere else in the country. I mean, Israel is a country of settlements. And of course, that is what the pioneers did even before the state was established. That was in fact how the country was built. But the reason, so the term settler doesn't really have any basis, as we discussed in international law. It really has, though, taken off as part of the political terminology, and it feeds in, of course, to the other political terminology that is used with respect to Israel. I see it as bearing a great deal of similarity to apartheid, to settler colonialism. All of that language has been developed principally in order to pursue the agenda against Israel. But in particular, Article 49 of the Fourth Geneva Convention, in which the word settler doesn't appear, is what has been underpinning the international discourse on Israeli settlements. That article provides that the occupying power shall not deport or transfer parts of its own civilian population in the territory that it occupies. That's the phraseology of the relevant section. You can see settler doesn't appear there at all, but it's on that basis that settlement policy has been criticised as a breach of international law by the International Court of Justice, the Security Council, the International Committee for the Red Cross, and various countries and international commentators. Now, there are two substantial errors with this criticism, and the first is the applicability of the provisions of the Geneva Convention to the West Bank. I explained that the Geneva Convention applies to situations of occupation, and I've already addressed why that label for the disputed territory is not legally appropriate. But the second error relates to the mischief which Article 49.6, which was the one I just read out, was designed to counter. Indeed, the context of that article is that it was drafted after in the aftermath of World War II and the forced transfer of populations by the Nazi regime. In fact, the full text of Article 49 prohibits individual or mass forcible transfers. So the article was directed against the heinous practice of the Nazi regime during its occupation of Europe of forcibly transporting populations of which it wished to rid itself into or out of occupied territories. And in the case of the Jews, this was the case for the purpose of killing them or to provide slave labor. So it's clear to me that the whole article is concerned with that forced transfer of populations against their will. And the last paragraph that I read out, paragraph 6, which relates to an occupier's own civilian population, it strikes me as also logically connected to that theme of forced transfer. And I think that's also apparent from the preparatory materials. So when the convention was being drafted, the discussions that are referred to in the travaux preparatoires indicate that these amendments were proposed and debated in the context of those transfers of populations against their will. So the application of these provisions to Israeli settlements remains problematic, as the settlement movement concerns individuals and collectives moving voluntarily to the area after 1967. The provision against transfer cannot objectively be construed to cover the voluntary movement of individuals, not as a result of state transfer, but of their own volition and as an expression of their personal choice. So the restriction on transfer we've seen is a restriction on government action. It's not a requirement that the government stop civilian movement into an area, although I should say that the Israeli government has on occasion done exactly this, where it had a legal basis on which to remove individuals settling on private land. But the spontaneous or voluntary movement of Israeli nationals, it simply doesn't trigger the text of Article 49.6. And I think the proof of the pudding is in how Israel is treated in relation to other states. And I mentioned the hope of coming on to this earlier. So it's a subject that has been developed but in a seminal piece of work by Professor Eugene Kontorovich, who has done an analysis of settlement situations, real situations of settlement and real situations of occupation around the world. And this is revealed that the international community has consistently acquiesced to government orchestrated settlement activity. Places like a situation of real occupation, so unlike the West Bank, but one that actually exists as contemplated by the Geneva Conventions, and also where this government orchestrated settlement activity forms part of its policy.
The normal hypocrisy and double standards, essentially.
Right, unfortunately. But to give our audience a sense of the scale of this, I mean, in East Timor, in the context of the Indonesian occupation, which involved a large-scale settlement enterprise, which explicitly aimed to change the demographic balance in that occupied territory in Western Sahara, where Morocco's settlement program is one of the longest and largest and most ambitious, in northern Cyprus, where the ongoing Turkish occupation constitutes one of the most substantial settlement enterprises today. And it's particularly noticeable because it takes place within the territory of the European Union. We also have the Syrian occupation of Lebanon, where there were mass movements of civilians into occupied territory between 1982 and 1990. In Cambodia, several 100,000 Vietnamese settlers came to Cambodia during a decade of occupation between 1978 and 1990. In Azerbaijan, where the Nagorno-Karabakh region has historically had substantial Armenian majority, or Armenia encouraged substantial immigration into the territory. And of course, I'm sure situations that will be very familiar to our audience during Russia's occupation in Georgia, Abkhazia, but also Ukraine, in Crimea. And it's worthy of note that there have been a centralized state-sponsored program to settle people in the territory, the explicit purpose of which is to change demographics again. Now, in many of these cases, the actions have been accompanied by large-scale human rights abuses. And in some cases, there has been international attention on those human rights abuses. And the case of Crimea has involved the imposition of sanctions on Russia, for many other violations of international law, but no country, no organization, no international human rights group has said anything about Crimea settlers.
What a surprise.
Or even attempted in any way to monitor the settlement activity. Now, I appreciate, Julian.
I'm itching to get the audience asking you questions, Natasha, at this point in time. I'm absolutely sure they have numerous questions to ask you. What I'm going to do is I'm going to ask the question that's come through on the chat, and I'm going to open it up to audience members. I suggest you unmute yourself, say who you are, and then please ask your question, and Natasha can answer it. Please make it a question. Question sort of what, who, when, how, not a lengthy statement if you can. But let's just go to this question in the chat. Excuse me. If one accepts Ms. Hausdorff's premise, does she think that Israel should encompass the whole of the West Bank? What would she do about the Palestinians? And I'll let you read the rest of the question there. What do you say about that? It's from Pamela Mayakoris, please.
Sure. So crucially, the analysis of uti possidetis juris gives us the starting point, and it debunks this myth that Israel is in the occupation or there is anything illegal attached to Israel's actions. But it doesn't say what exactly the current state of affairs is, and it certainly doesn't dictate any solution for the future. So I mentioned Israel's unilateral withdrawal from the Gaza Strip in 2005. There is a strong argument to say that on that basis, Israel unilaterally relinquished sovereign claim to that territory. And of course, that is now ruled absolutely by the terrorist regime Hamas. The situation in the West Bank is very much more complicated than that, because I mentioned the temporary administrative framework that Israel established in 1967. The peace, well, I say advisedly peace agreements, but the interim agreements that Israel entered into with the Palestinian Authority, or those that created the Palestinian Authority, I should say, the Oslo Accords, were very clear that they had no impact on sovereignty, and that would be a matter for final status negotiations. But the underlying situation hasn't impacted in any way Israel's sovereign claim to the territory. I certainly don't advocate for the sort of situation that Pamela was at the questioner was suggesting. I don't suggest that the underlying legal situation dictates the political decisions and agreements that Israel enters into with its neighbours.
Now, Richard Galber has asked a question. I know Richard Galber. He's no shrinking violet. He's a wonderful man. Richard, are you there? And can you unmute yourself? And maybe you want to ask your question, please. Or maybe he's disappeared. Richard Galber? I feel like a headmaster. I'll ask the question instead then. Isn't there an element of difference between the wording of the Geneva Convention and the ICC Rome Statute to try and include a voluntary movement of civilians into occupied territories? Do you want to answer that question? Thanks, Natasha.
There absolutely is. And it's the reason that neither Israel nor, in fact, the United States signed on to the Rome Statute. It was an indication from the very first moment that the too many states parties to the International Criminal Court intended it to be a political instrument. as opposed to an objective court. And that was the insertion of the words direct or indirect into the phraseology, where the issue of transfer from Article 49.6 is addressed in the Rome Statute. And that certainly does inform the position that the previous prosecutor, Fatou Bensouda, took in relation to her proposed investigation. And it may yet inform the position that Karim Khan, who is the very recent prosecutor that began recently, may take as well. But it is the only instance in which, it's telling, I think, particularly telling, the context in which those words were introduced. Does it affect the situation of the settlements in Israel? I don't think it does at all, because of the underlying legal position. That, of course, isn't changed by the insertion of those words. And to properly understand where the drafting came from, we do need to look at the context in which the provision was originally drafted in the Geneva Conventions.
Richard, do you have a follow-up for that at all, or any more questions from the floor, please?
Basically, just one thing.
They're very unclear. I can hardly hear you.
Is that better?
Much more. I need much louder. I need it. Sorry, Richard.
Hang on, is that any better?
Shout it and we should be able to hear you.
Okay. China has occupied Tibet and is almost committing a cultural genocide against the Tibetans, and nobody ever talks about it. It's never even, it doesn't get discussed in the UN or any of the other international forums. That's it.
Well, you're right that the focus internationally is consistently on Israel. And one actually only needs to look at the kind of resolutions that are passed by the Human Rights Council in Geneva and the focus that is placed upon Israel across the board, the fact that it is the only country to have its standing agenda item 7 that targets Israel. So what you're describing is not uncommon, and indeed Julian has cynically been remarking on it throughout.
Any more questions from the floor at all? Anyone else?
I'm conscious, Julian, that your question on Sheikh Jarrah is one that I had.
I've got two questions, in fact, Natasha. Before we discuss that one, I would like to discuss with you the ICC judgment on jurisdiction over Israel. What is your view on that judgment? I know there's a very powerful dissent in that particular case. And do you think the election of Mr. Khan as the new chief prosecutor at the ICC, an ex-CPS lawyer, I should add, will make any difference at all, please?
Well, I don't think anyone really knows what Karim Khan will do, although the fact that the previous prosecutor Bensouda began the investigation just before Khan's term was about to begin may suggest that is unlikely to have been done without consultation. But in relation to what you've described, this is a decision by Pre-Trial Chamber 1 on the question of jurisdiction that was raised by Fatou Bensouda. It is quite a light decision in comparison with a very heavy dissent.
Yeah.
It was the presiding judge, Judge Kovacs, that dissented and used language that is not often heard in court, I have to say, in terms of the lack of a legal basis for the decision that was made to determine that there was in fact jurisdiction for the court to begin its investigation. Now, that is not the last word on this matter, and the majority in that decision were clear to say that the question of jurisdiction would have to be dealt with at later stages in the process. So in a sense, they sort of dodged that part of the question. But what they did is they gave the green light to the opening of the investigation without grappling absolutely unbelievably, without grappling with key legal questions, such as whether Palestine might be properly in law determined to be a state. It's clear, I think, that the reason that they didn't engage in that level of analysis is that a state of Palestine wouldn't meet the internationally recognized criteria for statehood under the Montevideo convention. The court also, the pre-trial chamber also completely refused to engage with the effect of the Oslo Accords, which are, of course, what have established the Palestinian Authority in the West Bank, under which authority they have purported to sign up to the Rome Statute. They present themselves as a state. And the arguments associated with the Oslo Accords, which were made very powerfully by many friends of the court, amici, that submitted briefs to the pre-trial chamber in response to the prosecutor's request. I mean, all of that was just dismissed out of hand. It's incredibly troubling. I've written on it to say that it is really very dangerously, evidently turning the court into a political rather than a legal institution. And of course, that undermines the court's validity and its ability to be taken seriously in the international community. And Boris Johnson wrote in clear terms on that, the fact that the Prime Minister of the United Kingdom would come out to clearly call out this decision and the opening of an investigation is a very significant indication, along with, of course, the fact that there were many states to the Rome Statute that put in amici submissions as friends of the court to say these are all of the legal reasons why jurisdiction cannot possibly be found.
I'm going to ask you a question from the live chat. Although the General Assembly cannot pass legally binding resolution over international issues, the UN Security Council, which has the authority to do so, has passed a total of 6 Security Council resolutions in Israel on the matter, including UNSC Resolution 478, which affirmed the enactment of the 1980 Basic Jerusalem Law, declaring unified Jerusalem as Israel's eternal indivisible capital, was a violation of international law. The resolution advised member states to withdraw their diplomatic representation from the city. The Security Council, as the UN General, has consistently affirmed the position that East Jerusalem, open brackets, but not West Jerusalem, close brackets, is occupied Palestinian territory. Do you think this is invalid, as this resolution was not under chapter 7?
I wouldn't say that they are invalid, but they have no legal effect. These are political statements. Now, there is a situation in which a resolution not made under Chapter 7 can be held to still have binding effect, and that is if it is made under Chapter 6, but it also contains language such as decides, something to indicate that it was intended to have a legal effect. And I think certainly the resolutions that have been cited, but Security Council resolutions in respect of Israel generally do not contain that language and are therefore not legally binding. And that's not just because it's only in extreme situations that the Council will actually decide to pass a legally binding resolution as opposed to a political one. But it's also because of the dynamics on the Security Council, of course, the US veto, and while perhaps with the example of Security Council Resolution 2334, it was just at the tail end of the Obama administration. It was particularly controversial that the Americans sort of gave the green light for that to go through. But I think that's much easier to understand when you recognize that these resolutions don't in fact have legal effect, they are political. There is an argument, and we've seen it used in respect to the International Criminal Court, that when you have a sufficient quantity of these resolutions, they generate the sort of customary principle or customary rules that I explained in relation to uti potestatis juris. And a number of parties, and in fact, the prosecutor of the ICC relied on that in her reasoning, and it was substantially adopted by the majority. The big problem with that approach is that this is not widespread practice. This is only in relation to Israel. These are exceptions that are made with respect to Israel. And as I indicated right at the start, you cannot have a legal rule that applies only to a state, or in fact, general legal principles that apply equally to every other state, but that you single one out for different treatment. That's not appropriate. That's what these UN resolutions do. And that's why even if they are numerous in number, they're never going to get over the bar, in my opinion to actually generate law, because it's not general enough and it's not consistent enough, and it's not right that it's just focusing on one.
I think you may have answered the next question I'm going to ask you. I'm going to do a batch of two now. One is from Brian Fink. I'm going to go through that one first of all. How does the anti-Israel UN Security Resolution of 2016, from which the US abstained on Obama's instruction, affect the legal position? We all know that resolution. And I'm going to, in that batch, put in this question from Sarah Samuels. Why does this anti-Israel attitude counters anti-Semitism? And you can go on to that if you want. And I'm also going to go on to Judy's question as well, Wolominski's question. Three questions on the trot for you to have a look at. Lib Dem Friends of Israel state, quote, "It is discriminatory for right-wing Israeli secular organizations to use law to evict residents of Sheikh Jarrah when there is no equivalent law for Arabs and Palestinians. How can we respond to this?" Can you very briefly, I think, first of all, look at the question from Brian Fink about the 2016 infamous resolution, please, if possible, and then maybe go on to Judy Wolominski's concern, please.
Sure. You're absolutely right that is what I addressed in terms of Resolution 2334. It doesn't have legal effect. Does it create a difficult political situation? Absolutely. And unfortunately, not only the administration that allowed that resolution to pass in the US, but the current one does come out with unhelpful, in my opinion, unhelpful positions. Perhaps I can give this example, so it's not just my opinion. It's also coming from Mahmoud Abbas, the president of the Palestinian Authority. He famously said, with respect to the Obama administration's position on settlements, "How can I be less Palestinian than the president of the United States?" Now, what he meant by that is that when the president of the United States was taking a position and making demands that he wouldn't necessarily have been making even on his own behalf or on behalf of the Palestinian people, he was hamstrung when it came to the negotiation table. He couldn't come to negotiations asking for anything less than the United States was demanding on his behalf, or further less still, leave that table having obtained anything less. And we see this, of course, not just with respect to the United States, but the political statements by countries with respect to the situation. The idea that if one makes excessive demands on Israel that will make peace easier to achieve is totally inverted. It actually pushes peace further away because it puts unreasonable expectations on the table. And we see similar issues arising all of the time with respect to Jerusalem. Jerusalem is never going to be divided again. When it was not under Israeli sovereignty, Israeli control. I've already explained that the Jordanians ethnically cleansed Eastern Jerusalem during their occupation of it. There has only been freedom of religion in Jerusalem under Israeli sovereignty, and no responsible Israeli government is going to change that. It also has to be borne in mind that the situation that arose after the withdrawal from the Gaza Strip, which we've just been reminded last month of over 4,300 rockets that were fired by Hamas out of that territory that Israel vacated. No responsible Israeli government can see a similar situation being allowed to develop either in the West Bank or in its capital in Eastern Jerusalem.
Before you have a glass of water, you probably deserve one, or a cup of tea if you want one at this point in time. Judy's question, please, yes. on Sheikh Jarrah and the discrimination point. Maybe you'd like to please address that, please.
Well, we sort of bookend it. We started with that concept, and it's hugely important to talk about it. I have done a webinar with Professor Avi Bell, which is on the UK Lawyers for Israel Charitable Trust YouTube channel, which goes into this in an awful lot more detail. But it's the
responses, please.
So the response that Judy wishes to give, I'll absolutely try and arm her with some of the proper information on this, because much, of course, has been made. Again, I would say for political purposes of the property dispute in the Sheikh Jarrah neighborhood in Eastern Jerusalem. And this is another situation, Julian, where Israel's critics have distorted the facts. They've perverted international law. And they are also attempting to intimidate courts and law enforcement officials into adopting a bigoted approach, which is to demand that the state defy court orders and deny property owners their legal rights on the basis of the race of the relevant parties. Let's be clear that it's the people criticising Israel that are bringing race into the equation. The current dispute in Sheikh Jarrah involves several properties with tenants whose leases have expired, and in a few cases there are squatters with no tenancy rights at all. And they are on one side of the equation against owner landlords who have successfully won court orders evicting the squatters and the overstaying tenants. Now, it's important to stress that litigation over these properties has been the subject of decades, and it's gone all the way up to the Supreme Court. The owners of the property in these disputes acquired their rights through an uninterrupted chain of transactions from predecessors in title in the 19th century. Now, these legal rights were acquired under Ottoman law, and they remain good through the different governmental regimes since then, so British Mandate, Jordanian occupation, and purported annexation, and then subsequently Israeli. No one seriously disputes the validity of the transactions through which the current owners acquired their rights from their predecessors in title, and the tenants in these disputes acquired their leasehold rights through a chain from the Jordanian custodian of enemy property in the 1950s. Now, their rights as leaseholders, not owners, were reaffirmed in several Israeli court rulings, and that culminated in 1982 with the Israeli civil courts issuing rulings which adopted settlement agreements between the leaseholders' predecessors in title and the owners. The only break in the owner's uninterrupted chain is the seizure of these properties from 1948 to 1967 by the Jordanian custodian of enemy property. And this is when Jordan, as I explained, during its occupation of Eastern Jerusalem and the West Bank, ethnically cleansed these areas of Jews. So the Jordanians transferred custody over all Jewish-owned property to the Jordanian custodian of enemy property. However, and this is crucial, it never transferred title to any party, and it never extinguished the owner's rights. Instead, what the custodian did was lease some of the properties to Arabs who were the predecessors to the current overstaying tenants. And when Israel regained the territory in 1967 and Jordan's occupation ended, Israel adopted legislation that vindicated the private property rights of persons of all ethnicities. Israeli law doesn't distinguish on the basis of race. So we had the 1970 Law and Administrative Arrangements Law, preserving the rights of private parties who'd received title from the Jordanian custodian of enemy property. And that was done notwithstanding the illegality of Jordan's occupation and the fact that those who received rights from the Jordanian custodian were all Arabs, since Jordanian law denied property rights to Jews. Julian, ironically, if the Jordanian custodian of enemy property had assigned title to the predecessors of the current Arab holdover tenants, had assigned title over the lands that it had seized from the Jewish owners, then Israeli law would have respected that resulting title. So the reason the holdover tenants in Sheikh Jarrah lack ownership today is not because the state of Israel has denied any rights to Palestinian Arabs, but rather because the government of Jordan declined to give those Arab tenants title to the land. So Israel's not granted anyone ownership of the affected properties. Israel is not in any way a party to this case. It is a private property dispute. The only intervention is that of the Attorney General to delay the decision, but he has subsequently indicated that he's not going to involve himself in the case itself.
What's the current situation, before we go on to the next question, please, in relation to that dispute? I think that was just in May of this year he got involved, didn't he? I think, and then it's since then what's happened to the matter? Do you know at all or not?
So the involvement was only to delay the decision because of the situation. There are many who have called that a form of blackmail, and that the security situation meant that the courts were not going through their proper processes. But I think there's every expectation that that decision will be handed down. when I'm not clear on. One additional factor perhaps to just bear in mind is that there is a mechanism in Israeli property law, as I understand it, of tenants such as these being able to ask the court for discretionary relief. Now, usually that is done upon any rent arrears being satisfied, but there's no requirement. It is simply a case that the tenants say to the court, for no particular reason whatsoever, but in our circumstances, please, will you let us stay? And my understanding is that that application for discretionary relief has not been made.
Like in any functioning civil court anywhere in the world in relation to wanting relief from forfeiture, etc., etc.
And you are far more the expert on property law here, Julian, than I am. But my understanding actually is that the room for discretion available in Israel is far greater, in fact, than under English law.
I just want to take it back to the floor. I think, Judy, would you like to ask a question at all? If you want to unmute yourself, please.
I wanted to raise the last part of the question, which was a key point, which is not legal position with respect to Sheikh Jarrah, but the Lib Dems, who we're having a big argument with at the moment, are saying that there's no equivalent law for Arabs and Palestinians. Is that true? And if it's not true, how can we show that that's not true?
So it's not that there is an equivalency between the laws. And what is often being referred to is a separate 1950 law to do with absentee property. There are parallels in that there is a custodian for absentee property in the same way that there was a Jordanian custodian of enemy property. And the difference comes down to how those custodians have handled the properties that they were entrusted with. Now, I've already explained that the Jordanian custodian of enemy property didn't transfer those property rights to anyone. So when the territory reverted back to Israel, the original owner's rights had been preserved. And with respect to the properties governed by the 1950 absentee law, the situation, of course, it is dependent on the individual situation in each of those circumstances. I do understand what you're saying, and I think probably a succinct response is to try and explain that property rights do not give immigration rights, because what is being argued for is that any individual property owners that left in the 1948 war, this is Israel's War of Independence, where it was attacked by its neighbours, and indeed some of the local population joined that attack as well. Certain elements didn't, and those elements and their descendants live as free citizens of the State of Israel, as Arab Israelis. They are, in fact, the only Arabs in the Middle East to live in a true democracy. So the question attaches to, what is the situation for those that left? Similarly, of course, there were 850,000 estimated Jewish refugees from Arab countries that were actually expelled out of their homes and found refuge in Israel. But the question as to the property rights of individuals whose properties fall under the absentee law, that is yet to be determined. As with many other situations of conflict, a peace agreement is expected to make provision for the form of compensation, if there is indeed to be compensation payable to any property owners who have not had their property restored to them. But crucially, you need to distinguish, and I think I haven't come across, forgive me, the argument, and I've struggled to find your question in the chat, I'm afraid. But it strikes me that the argument that you are referring to is one that conflates property rights, immigration rights. It conflates the 1950 law and the 1970 law, which do not act in any way on the basis of race. But it also advocates for the Israeli legal system making distinctions in terms of the race of parties. And that is reprehensible, and that is something that needs to be pushed back on, because that is the racist approach to this property dispute.
I'm just going to ask Andrew and Paula Ahrens to unmute themselves. Lucky you! I feel like a quiz show host. It's very exciting. This is much more exciting than Wimbledon Magistrates Court. If you could unmute yourselves, please.
Done.
And And please ask your very good questions to Natasha, and for her to answer them, please, if possible.
And okay, Julian, me first. Do we know why the Jordanian custodian didn't transfer title? Was there a specific reason? I mean, were they ignorant?
I don't know that there's anything being written about this. I can assume that it might have had something to do with not wanting to bestow. Well, they made the Jordanian custodian made the decision to bestow leasehold rights and not ownership. The reasons behind that I don't know. But I would be I mean, no one is talking about, the reasons that Jordanian property law forbade Jews from owning property or any of those. I mean, the questions on this are particularly, and it's not yours, don't get me wrong, it's the way and the lens through which this situation is being viewed. There wouldn't have been anything to stop the Jordanian custodian confiscating this property and tearing up the Jewish ownership rights and bestowing those on the Arab individuals. I can't think there was anything that would have prevented that.
I've got another question. Would you agree that as Jordan has no legal right of disposition, its assertion that it handed to Palestinian Arabs claims over Jerusalem has no basis, and that therefore only Israel has grounds arising from the San Remo Conference and the British mandate regarding sovereignty over Jerusalem? Natasha, any response to that, please?
Again, I think we need to be very careful here about a distinction between property rights and rights of sovereignty, because they are different things entirely. I would argue that Israel's sovereign claim goes back to the Declaration of Independence, 1948, and in fact, the court in Burkina Faso, Mali, and the International Court of Justice, when it was dealing with the principle of uti possidetis juris, referred to this moment as a snapshot of the territory at the critical date of independence. And so that's why 1948 is so crucial into establishing what Israel's sovereign rights were at the time. The interesting thing with respect to the Jordanian position is that Israel has respected property rights created by prior regimes, even those that explicitly discriminated against Jews in their property laws. And that's, of course, not just the Jordanians, but also the Ottoman Empire, the British Mandate as well. And so this is it's a concept in international law of sequestration, and the laws that have applied elsewhere have been applied by Israel. Or the principles in adopting the position that was taken by the Jordanian custodian of enemy property. So Israel's recognized it and abides by the position that was established by 1967. So it's actually not the situation that, certainly Israeli law hasn't said that any decisions taken by the Jordanians were totally illegitimate. Quite the contrary. You mentioned the San Remo Conference. I think that is crucial in terms of the political and the historical context of Israel's declaration of independence. And there are many academics that argue that that has significance in international law because of the commitment that was made by the international community. But I would say that really it's Israel's declaration of independence. We don't need special treatment for Israel. Its legitimacy and its borders should be recognized in the same way that any state coming into existence. And the general principles of international law, and in particular the rule of customary law, uti possidetis juris, should be applied equally to Israel's case as well.
Now we're in extra time, everyone. We've been going for an hour. And you've really been put on the spot, Natasha, but I would love anyone else has questions for her. I mean, this is so interesting. Let's go on for a few more minutes. Everyone's happy to.
Great.
So if before I ask the live, any questions from the audience? You want to unmute yourself and ask yourself a question live at all, anyone? I said last 15 minutes, 10 minutes. Okay, I'll ask the chat question otherwise. Anyone going once, going twice?
Yes, please.
Oh, yes, hold on. Who is this? Sorry.
Mervyn Smith.
Mr. Mervyn Smith, you are live. There are 10 minutes to go. England 2-0 down. You come on the pitch, or is Scotland 2-0 down, which is quite typical, really. Speak.
Right. My understanding is that the Jews were granted land, including the Jordan Valley, by the British Mandate in 1922. When the State of Israel was established, the UN recognized the British Mandate's arrangement, and under, I think it's Article 8, agreed that Israel should have the rights over the Jordan Valley and parts of Judea Samaria. The Jordanians then threw the Jews out in 1948, and the Jews came back and established settlements in 1967. Why is it not left to these facts, if I'm correct, to confirm that there are no grounds for the Jews to leave the areas that were acknowledged by the British Mandate and by the United Nations, leaving part of the West Bank still open for discussion between Israel and the Palestinians, which is, in my opinion, unlikely ever to take place.
So I think we need to be careful about the suggestion that anything was ever granted to Israel. And this is why the Declaration of Independence and the legal position arising out of that is so important. Not least because if there's a suggestion that the international community may grant something, then there may also be a suggestion that they can take it away. And that's just not how international legal order works. You're absolutely right that there were provisions made for the establishment of a Jewish national home that the mandate was intended to facilitate. And I see that similarly to the San Remo commitments as important historical, also in some respects legal context, because declarations that are made officially on behalf of states do have a binding effect on them. But we don't even need to go into all of that when we just say treat Israel as you do any other state and any other state as they're coming into existence. Apply customary international law equally and you have your answer. And that is what I set out in some detail in looking at the legal status. So I think that's probably, I mean, that's the best answer that I think that that I'm able to offer, but I think also crucially it's the correct one. It's one that isn't grappled with properly. It's one that was raised with the prosecutor at the International Criminal Court, who didn't grapple with the subject matter, unfortunately. She fell back on, for example, the principle of self-determination. Now, that's an interesting point because case law on uti possidetis juris has actually been very clear in indicating that this principle, which supports stability and clear lines as borders, should actually trump any competing interests or claims of self-determination. Although, you know, that might be very much more a controversial position to take today than in the time of the Burkina Faso Mali case. But I think what's crucial to be clear on is that Israel's Declaration of Independence, the establishment of the state, predates the claims of self-determination that are being made today, and those therefore have to be dealt with within the context of pre-existing sovereign states. The Canadian Supreme Court case of Quebec was very clear. And actually set out in great detail development of the principle of self-determination and how it can feasibly be exercised within an existing framework of an existing sovereign state. Self-determination doesn't give you a state of your own, and in fact does rather militate towards exactly what you're describing. And exactly what the parties across the board have accepted, that any solution has to be negotiated. The parties have to come to the table in order to do that, and cannot be done crucially, I indicated the unreasonable demands that were being made that pushed peace further away by significant elements of the international community. But there's also an important issue here of starting on the wrong legal basis, right? That the narrative that we are all very familiar with, which is entirely contrary to what I've set out to you today, and incorrect, is also incredibly damaging because it means that any sensible legal political negotiation isn't starting on the right foot. And that's something that we all need to be prepared, I think, to grapple with very robustly, and to push back against the misrepresentations and the abuse of international law. And as with any of these damaging trends, it may be starting with Israel, it may be primarily targeting Israel, but the impact that this abuse has is far greater than Israel. It undermines and devalues international law across the board because of the principle of its equal application. And where that is not being done, and these are political acts, political claims and political calls, as opposed to legal ones, that worsening of all sensible conversation and debate and discussion and productive negotiation.
I'm going to take 2 more questions. I've got a glass of single malt waiting for me, which is going to take priority in a few moments' time. But any more questions at all from anyone? If you want to unmute yourself, please do.
I don't know whether you can hear me.
Yes, I can, sir. Yes, I can, Mr. Simons, please.
Yes, I just have a bit of a layman's question, actually. You know, whenever you turn the television on or read the newspaper and it's covering the situation between Israel and the Palestinians, the territory of the Palestinians that they are on is always referred to as the occupied territories. And, you know, the term the occupied territories, to my way of thinking, always casts Israel in the role of the aggressor, the occupier. And I mean, whether it comes across like that to other people, I don't know, but whenever I hear them, and it's constantly bandied around, that term, the occupied territories, in the connotation of the, you know, the situation there, whatever it is. And I'm wondering whether the term used by the media, supposedly in an impartial way, can be challenged as not being impartial.
I think that's exactly what we have to do, because not only is it not impartial, it's also fundamentally incorrect. It's certainly not legally correct, but it's also a misrepresentation of the underlying status of the territory, of the history, and promotes a narrative that is incredibly damaging. So no, I'd absolutely agree with you. And it sounds legalistic, doesn't it? It comes with perhaps the additional legitimacy of law, but it is part and parcel, and I mentioned some of these terms earlier on, of a big push in academia to delegitimize Israel with painting it as a colonial entity, a colonial occupier. The notion that the Jews who have been colonized throughout history can now be painted as colonizers is utterly ludicrous and totally at odds.
I should say, Mr. Simons, that if you complain to the BBC and your complaint is upheld by the BBC editorial department, I will buy you a bottle of single malt whiskey. In fact, I'll buy you 3 bottles of single malt whiskey. Such will be the chance of that. And if you manage to get a copy of the Bailin report that was withheld by the BBC, I think 14, 15 years ago, I'll give you a crate of single malt whiskey and my children and my house as well. As you know, there was a report written some years ago by the BBC, but there's no offer, consideration, offer and acceptance, and there's no intention to create legal relations in that comment by me.
Well, I should say, Julian, we are on the case and have been asking for some time now, but also increasingly with the recent controversies surrounding the BBC for the publication of that report. The suggestion is that there is some damning material if it would have been buried for such a long time. But even leaving that report aside, I think it's crucially important that we have opportunities like this to push back on these terms.
Do you think, just before we go on to two more questions, do you think 16 years on or 15 years on the Bailey report, if an FOI request is made now, there will be more chance, because it's historic only, of getting the report in litigation or not, in relation to that report? As
far as I'm aware, there are ongoing FOI requests, and they have not yet been successful, but who knows? The difficulty and the hurdle, unfortunately, is only becoming greater as reporting on this develops, is that these terms are becoming accepted. And part of that, I indicated, is because of the agenda that is being promoted through academia. But an awful lot of that is also arising from NGOs, so-called civil society organizations with substantial amounts of funding that have been set up principally for the purpose of driving an anti-Israel agenda. Reports, well, we've even seen a recent report that did make substantial headlines from Human Rights Watch, calling Israel out as an apartheid state, which is ludicrous to anyone who's actually been there and witnessed or knows Israeli Arabs and the full part that they take in society in Israel. Also embraced by the government, and so the Foreign Commonwealth Development Office uses that terminology. So
just in relation to the BBC, we're going to go on to a couple of questions. I think it's also very important. It's not just the media reports, it's their website too. What is on their website in particular for kids? They will research online. It becomes gospel, excuse the word in this context. So it's very important that those untruths are taken out. There's a very interesting comment from Morris saying there have been 400 FOI requests to release the Bailey report, and each one has been unsuccessful. Well, let's hope there's a 401st one that's successful.
I should say, though, with respect to the BBC and its educational output, BBC Bite Size had tremendously troubling material, videos on the Middle East conflict, and with very careful, painstaking work by UK Lawyers for Israel, those have been removed. The hope is that something more balanced can be put out and something more accurate, rather than the false misrepresentations.
I think 15 years on from the Bailey report, that is now the biggest battle area. It's not a report by Jeremy Bowen. It's not a report from someone on the scene in Israel. It is the website. Material on the website. It stays there. Kids look at it. Kids use it as for research 101 on the conflict. Can I? Do we as Jews, subject to so much oppression and eviction over centuries, not view it as our humanitarian duty to ensure that Palestinians enjoy safety and security? Natasha, what would you say about that?
Oh, I'd absolutely agree. And I think Israel takes that duty far more seriously than, unfortunately, the international community, and desperately, unfortunately, the Palestinian leadership. Israel has consistently done more, and I don't just mean for Israeli Arabs, those who are citizens of Israel, but if you poll Palestinians living, when people have polled Palestinians living in the West Bank, and they are able to answer honestly, consistently, they say they would, in any scenario, prefer to be citizens of Israel than citizens of any future Palestinian state, because of the way that they have been treated by their own leadership, by the rest of the Arab world, and by, unfortunately, the international community. I mean, the continued support for UNRWA, perpetuating a refugee status across generations, which is unique to the Palestinians. It doesn't exist anywhere else. That level of abuse and oppression that the Palestinians have been suffering, and I stress not by Israel, is shocking, and it's not reported on. When I've spoken at the UN Human Rights Council in Geneva, one of my speeches was dedicated to the treatment of Palestinians by the Palestinian leadership and many surrounding Arab states. And we do need to be raising our voices and addressing that situation. And I see that as an element of humanity, as opposed to strictly rooted in Jewish tradition, but Jewish teaching can only heighten the importance of doing that. But that does not mean that we can be hesitant in pushing back against the misrepresentations and the blood libels, because of course this is the modern form of the blood libel. The accusations have been made against Israel that have no basis in reality. In the Middle Ages, anti-Semitism manifested itself in the myth that Jews killed Christian children to use their blood to make matzah. That developed through post the Enlightenment period, when anti-Semitism had more of a scientific basis, or I should say a pseudo-scientific basis, where eugenics was used to justify Jew hate against the race. Well, today, and of course, Lord Rabbi Jonathan Sacks has made this point many, many times before his passing, and far more eloquently than I'm able to myself. But his analysis indicated that the modern form of anti-Semitism presented itself against the Jewish state, and this was the modern form of the blood libel, to call Israel an oppressive, colonial, apartheid, ethnic cleansing regime, where none of those things are true, because it is the language of human rights and international law that are the modern order of the day, in the way that science was previously and religion was previous to that. And that's something that we need to do in combination. Fight for Palestinian rights and fight against the blood libels against the state of Israel.
Thank you so much, Natasha. That was a real tour de force. I see people are trying to clap on their screens at the moment. That was a real tour de force. It's been a total privilege for Wimbledon. You can see in South London we don't bite, but for you to come and give this talk to us, you were a real fighter on television. I know that, for Israel and for pro-Israel advocacy during the recent conflict in Gaza. I know you were on Sky News. I saw you're on other TV channels, in the radio as well, and to have such an eloquent and articulate person such as yourself advocating for Israel in this country makes such a huge difference. And you're also very brave doing it. I can't imagine the type of vitriol and abuse you've got from it as well. And huge kol hakavod and huge respect to you for doing this. And I think it's a real privilege that you've been able to give us this talk and show us your knowledge and learning on the subject, as I've got a single malt waiting for me at this point in time, and I hope you got a large glass of wine for yourself. As I said, South London doesn't bite, but unless I allow Judy Welleminski to give the vote of thanks, she may well bite. So I'm going to put us over to her now. And again, thank you so much. Thank you so much.
Well, it's very difficult to follow and give a vote of thanks when I've had it given so effectively by Julian. I echo everything that he said, and I hope I've got this correct, but the big message I take away from your talk is that we need to focus much more on the Declaration of Independence and how foundational that is in the right of Israel, not only to exist, but also in its status in Judea and Samaria and all that follows from that. And we need to not let people divert us from that foundational point. That's a big message I got. Did I get that right?
Absolutely, that's the critical date, and that really puts the lie to the arguments in international law that are being circulated so frequently on Israel. So if anyone here feels better able to contend with those issues and that subject matter, then I'm tremendously grateful for the time that you've given this evening and for your questions, and Judy for organising and hosting.
Well, thank you for that. And it wasn't just me, but we all thought you were absolutely fantastic. Can I just take a moment to advertise the next South London Israel Forum event, which is on the 8th of July, when it'll be a talk by Noru Tzalik, and many of you will have heard Noru talk before, who always gives a fascinating aspect to everything. And he will be talking on Israel and Gaza, what you always wanted to know but never dared to ask.
Can I also add, if any of you want to, please do join UK Lawyers for Israel, which Natasha is the director of. If you are a lawyer out there, or a law student, or know a law student or lawyers, please do get them to join the UK Lawyers for Israel. And of course, on a practical level, to join the Zionist Federation as well. But certainly if you're a lawyer, please join UKLFI. It's a great organisation, does huge amounts of work behind the radar for the last 8, 9 years, 10 years now. I was a director for some years, not anymore. My footsteps have been taken by someone brilliant, which is good news. And thank you so much. Any more announcements, Michael, at all? Anything to say?
Over to Michael for him to make his contribution.
Well, the thing I'll be taking away, Natasha, is the YouTube recording, so I can listen to it all again, because there was so much information that you gave us there in an hour. Certainly for a non-lawyer such as myself, I will need to listen to it again slowly in order to be able to take it all in.